Thank you, Madam Governor. And I would like to lead off the questions. I appreciate your testimony. On the issue of the exemption, on page 5 of your testimony, you talk about that, and you said this in your statement, that the statute applies these provisions to all issuers, talking about the exclusivity portion of it, including the small issuers and the government-administered payment and other prepaid programs. As you're well aware, and you state in your statement, this is an issue that has brought many questions as to whether the exemption for community banks and credit unions can actually result in exempting them from the interchange fee. And you mentioned in your statement pretty through, and actually Mr. Bernanke said today, which I'm sure you're probably not quite aware of because he just stood in another committee, that there's some risk that the exemption will not be effective. Could you speak a bit about how this exemption can hold up through the different parameters that you're charged with?
Certainly, thank you for that question. Yes, small banks are exempt. They are exempt from the interchange rule portion of this section of the law, and they are also made to be exempt in the proposed rule that the Federal Reserve has put out for comment. The small issuer exemption is looked at from the perspective of asset size, so it's at a $10 billion level, and that's looked at from the perspective of the size of the issuer as well as its affiliates and subsidiaries. But as you note, small banks and credit unions do in fact have concerns about this exemption, and they note in particular that the law does not put the similar exemption that it has in the interchange fee portion into the other portion of the law. So the exemption does not apply in the provisions having to do with network exclusivity and the routing restrictions. To elaborate on the Chairman Bernanke's comments of earlier, there are, I think, legitimate questions regarding how, in fact, small issuers are going to, in essence, have this exemption work in their favor, because there is indeed no statutory authority provided in the law that would permit the networks to, in fact, engage in two-tier pricing. So it is a matter of whether the networks, in fact, will put two tiers of pricing in place and the extent to which that pricing becomes maintainable, or whether, in fact, it gets eroded by market forces.
Right, and the question being that if you're an issuer from a community bank or a credit union, that your interchange fee could remain higher. Will there be, as you said, downward pressure to move customers towards the lower cost interchange issuers? The second question I have is on the fraud provision, because this is the one that I've heard a lot about. And in your statement, you mentioned at the very end, after considering the comments that received, the board plans to issue a specific proposal on the fraud prevention adjustment. My understanding is that the Reserve felt that the language was written so tightly that to calculate for fraud prevention was not included in the parameters of when you were looking at the costs, the incremental costs. What do you mean by the comment? Are you actually going to be calculating this, or is this something, obviously this is going to come through in the comments. Do you have a comment on that?
Sure. The whole issue of fraud prevention costs is dealt with explicitly in the statute. So the statute has directed the Federal Reserve Board to allow for a fraud prevention adjustment that takes into account fraud prevention costs. And essentially what we're directed to do by law is to develop standards for what those fraud prevention
costs. But not a pricing standard.
It is actually silent on standards, but essentially the law requires us to develop standards. And what we have done, because this is an area that I think is something we want to learn more about, is in our proposed rule, we have asked for comment on what fraud prevention costs might in fact be costs that we should consider before we promulgate the final rule. So we have, in fact, adhered to the notion that fraud prevention costs are something that standards need to be developed for, and we really await with some eagerness the comments that we receive and review them so that we can determine what makes sense.
Right. Thank you. I'll turn to our ranking member for questions.